It was with great sadness that I learned that Scott Craigie, the former Chief of Staff for Governor Bob Miller from Nevada, passed away last Tuesday. He was a tireless advocate for seniors and children, and an effective one at that. Scott knew how to get done. That's why he was put in charge of the successful Education First constitutional amendment campaign in 2004. Which forced the state legislature to vote on an education funding bill before any other appropriation. Scott also gave me my first start in public service. He hired me for my first professional job in the legislative world, and I owe him my career. He believed in me and gave me a chance. Scott, I will do my best to continue fighting for those who need someone to stand up for them. Rest in peace, my friend. My thoughts and prayers are with your family, with our friends, and with the people of Nevada whose lives were touched because of you. God bless you.
The gentleman yields. The chair lays before the House the following personal requests.
Leave of absence requested for Mr. Graves of Georgia for today, Mr. Gary G. Miller of California for today and the balance of the week, Mr. Danny Davis of Illinois for today, Ms. McCollum of Minnesota for today and tomorrow.
Without objection, the requests are granted. Under the Speaker's announced policy of January 3, 2013, the gentleman from Nevada, Mr. Horsford, is recognized for 60 minutes as the designee of the Minority Leader.
Thank you, Mr. Speaker. 60 years ago, America was a country entrenched in inequality. Whites and African Americans were treated as two separate classes. Our society's education system, perhaps our most influential and important institution for future success, kept white and black children separate and wholly unequal. And then, in 1954, the Supreme Court's decision in Brown versus the Board of Education, argued and won by the legendary Justice Thurgood Marshall, rewove the fabric of our divided nation and moved our country down the path towards the civil rights victories of the 1960s. The decision was, according to Sherilyn Ifill, the current president of the NAACP Legal Defense and Education Fund, quote, the beginning of the end of legal apartheid in the United States. Laws of the Jim Crow that were intentionally designed to ensure that blacks and whites were not treated equally were finally questioned by our nation's highest courts. The dream of a country where all men are created equal and treated equally under the law became a potential reality. But it would still take decades of tireless activism by multiple generations of civil rights leaders and organizers to get us where we are today. Brown versus Board, this decision was the first step toward a reality of equality and was a drastic change for a court that had previously been detrimental to past civil rights actions and cases. So we're here today as the Congressional Black Caucus to reflect on America 60 years after the Brown versus Board of Education decision. What impacts have we seen, and what challenges still remain with achieving a society that truly lives up to the 14th Amendment's equal protection under the law clause? What steps must still be taken to achieve a society that lives up to the dream of the civil rights movement, where the color of one's skin does not determine their ability to succeed? Mr. Speaker, tonight I'm proud to be joined by colleagues who have been part of this effort, this ongoing effort towards realizing the full potential of what the Brown decision means for every single child in America. We'd like to start first with the gentleman from Virginia, my good friend, who has been a champion for working families and who recently was part of a forum at George Mason University talking about the issue of the Brown decision and where we are today. I'd like to yield to the gentleman from Virginia, Representative Bobby Scott.
Thank you, and thank you, Mr. Speaker, and thank you, the gentleman from Nevada, for calling this special occasion to give us the opportunity to celebrate the 60th anniversary of the Supreme Court case of Brown versus Board of Education. As a representative from Virginia, I take personal pride in celebrating this anniversary because Virginia played such a prominent role in that case. In fact, one of the cases, 4 cases combined that the Brown decision, that were combined into the Brown decision, was Davis versus the County School Board of Prince Edward County in Virginia. 2 of the nation's premier constitutional lawyers were involved in the case, Oliver Hill and Spotswood Robinson, both from Virginia. In the Brown decision, the United States Supreme Court unanimously struck down the legal footing for racial segregation in public schools in this country. The decision overturned Plessy v. Ferguson, an 1896 case that held that a state could maintain separate but equal public accommodations. In Brown, the court highlighted the importance of education in language that still rings true today. The court said, "Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms." We come then to the question presented: does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. The court then concluded that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Unfortunately, although the decision was a victory for minority students, not everyone was eager to comply. Virginia led the resistance to the Brown decision. Ironically, Virginia used the language in the decision as its legal grounds for what they called massive resistance, where it said such an opportunity where the state has undertaken to provide it is a right which must be made to all on equal terms. Virginia reasoned that it could avoid integrating the schools by having no schools at all. And so in Prince Edward County, they closed the schools for several years. Schools were also closed in Norfolk and Front Royal and Charlottesville. We overcame massive resistance after several years, and those schools eventually reopened. But now here we are, 6 decades after Brown. Thankfully, we've made progress, but we still have work to do. The promise of equal educational opportunities envisioned by Brown remains unfulfilled. For example, equal educational opportunity does not occur when one jurisdiction spends substantially more per student than an adjacent jurisdiction because of the relative differences in wealth between the 2 jurisdictions. Unequal funding results in unequal educational opportunities when you consider that studies have shown that 1/2 of low-income students who are qualified to attend college do not attend because they can't afford to. In fact, today, a high-income, low-achieving student is more likely to attend college than a high-achieving, low-income student. Another example of educational inequality is the current debate over publicly financed school vouchers, which can be used at